ABA Formal Opinion 518 is important not only for mediators, but it's also important for the attorneys that hire us as mediators. What the opinion does is it clarifies our role as mediators, that we're not representing anybody. It clarifies the importance of confidentiality, truthfulness, and neutrality. I think it may come as a surprise to some people that the opinion even had to mention the issue of truthfulness. But there's always been an issue in the legal world where lawyers are allowed to engage in a certain amount of puffery or misdirection or whatever you want to call it in negotiation. And what this opinion makes clear is that when lawyers are acting in the role of a mediator, they absolutely have to be truthful to the parties, and that the parties do have a right to rely on the mediator being a truthful carrier of information. For most mediators, this doesn't really change what we've been doing. From the time I started mediating, I've always believed that I have an obligation to be truthful with parties. Most of us have had that belief, and that belief comes from the importance of the mediator being a neutral party. But because there were other ethics opinions that suggested that an attorney did not always have to be honest in negotiations, this new formal opinion from the ABA makes it clear that when attorneys are acting in the role of a mediator, they absolutely have to be truthful with the parties. We can't represent what one party said when we're talking with the other, and we can't imply anything that's other than truthful when we're engaged in a mediation. There's one nuance in Formal Opinion 518 that I think could use a little bit of explanation. But I think the opinion as it stands is fine. And that is, mediators are allowed to tell the parties what they think the likely outcome would be if the case went to trial. That's an important role that an evaluative mediator plays. But the opinion is clear that we are not permitted to tell a party that a settlement is in their best interest because the court might rule against them. And that might seem like a nuanced distinction, but it's an important one. Because one of the foundational principles of mediation is that parties have a right to self-determination. So it's really between the party and their lawyer to determine whether or not a settlement's in their best interest. It's really not the role of the mediator to tell a party that a settlement is in their best interest.